go ahead and begin with our introduction, and hopefully our last committee member will be with us shortly. Hello, everyone, and welcome to this, the 79th meeting of the Native American Graves Protection and Repatriation Review Committee. My name is Melanie O'Brien, and I'm the designated federal official to the Review Committee. I'd like to welcome the Review Committee members, the National NAGPRA program staff, and everyone in attendance. I continue to be pleased that this virtual meeting format has allowed so many of you to join us for these meetings. This is the fifth meeting in a series of scheduled meetings. We have one more scheduled next week. The meeting schedule is available on the National NAGPRA program events page, and I'll put a link in the chat. Before we begin, I would like to remind everyone that this meeting is being recorded. The recording, transcripts, and meeting minutes will be made publicly available after this meeting and will include the names of all of those in attendance during today's call. If you object to this, you may disconnect at this time.
Madam Chair, Madam DFO rather, sorry.
Yes,
it says here my video's turned off.
Yes, try again. I think I
Good afternoon.
had to click a button.
There we go. Okay, there we go. Thank you. Sorry.
No problem. This is a meeting of the Federal Advisory Committee established by the Native American Graves Protection and Repatriation Act, or NAGPRA, of 1990. And this meeting is regulated by the Federal Advisory Committee Act, or FACA, and its implementing regulations. This meeting was noticed in the Federal Register on December 10th, 2021. An agenda for this meeting, as well as materials for this meeting, are posted to the NAGPRA program events page. The FACA charter governs the objectives and scope of activities for this committee. The purpose of the review committee is to monitor and review the implementation of the inventory and identification process and repatriation activities under sections 5, 6, and 7 of the Act. The committee is also responsible for reporting to Congress on progress and any barriers encountered in carrying out its responsibilities. With that as introduction, I'd like to start with a roll call of members. If you could please answer out loud. John Beaver.
Present.
Honor Keeler.
Here.
Barnaby Lewis.
Here.
Timothy McEwen.
Here.
Frank McManaman.
Present.
Shelby Tisdale.
Present.
Currently, the review committee only has 6 appointed members. The charter for the review committee does not contain our quorum requirement, and a meeting may be held with fewer than 7 members present. As the DFO for this committee, I have determined that the meeting can proceed with only 6 members present. Frank McManaman was selected as the chair of this committee. Mr. Chair, I hereby call this meeting to order.
Thank you, Madam DFO. I believe our first order of business is that Barnaby Lewis has agreed to give us a traditional prayer for opening the meeting. Barnaby, thank you. Barnaby, your mic may be muted. Could you take a look?
Oh, okay, I see it now. Sorry about that.
Thank you very much.
which met nako ko eju open my wap ki qui at masma matam de nako ko eju open sap buchi jakit matava hirimusha kodota hidden tasha chitan exam to them masma mat gvusi choju ai sapo nye to ap sapo hui nyenyo kat masma matam de eju ko sharing here the chanye masma matam de nako ko eju gvusi cho Sapi wush yamjit that humapik. I must make chui given sure but wa she bites you go hooker. I see her that much former she hides your about get him that. It must may aim at them that it's not go joke. By she wush it just up or wap oil what either job at them. By she go hooker toner they get here that good. But them did much knuckle go joke. Cause up wush I just sick to. First it is the much touch you go it tired eyes and your virgin. Who should eat them at tight who come a virgin. Thank you.
Barnaby, thank you very much once again for that blessing. Madam DFO?
Yes, before we begin with the first agenda item today, I would like to acknowledge the individuals who are assisting me with conducting today's meeting. With me are two attorneys from the Department of the Interior's Office of the Solicitor. We have Brady Blasco from the Division of Parks and Wildlife and Stephen Simpson from the Division of Indian Affairs. From the National NAGPRA program, Lisa Koszalski is the review committee coordinator who is responsible for organizing this meeting and preparing the minutes and transcripts of these proceedings. I greatly appreciate other members of the NAGPRA program staff, as well as those with the Department of the Interior who have assisted me in preparing for today's meeting. The first item on the agenda today is a presentation from the University of Missouri Museum of Anthropology. With us is Candace Saul.
Hello. I have a PowerPoint to show if that's helpful.
Yes, Candace, you should be able to share your screen.
Okay. There we go. Thank you. Can everyone see it now? Is that correct? You can see the intro. Thank you. Thank you, Madam DFO. Thank you, Mr. Chairman and committee, for allowing me to talk with you today. My name is Candace Saul, and I'm the new director of the Museum of Anthropology here at the University of Missouri. I'm speaking to you from lands that are the ancestral homes of several tribes, including our namesake, Missouri, here in Missouri. I'm here to offer you an update on our progress on our NAGPRA consultation and documentation grants. Here's a map of Missouri. I know Missouri is my life, but you guys may not be as familiar. Of course, we have the Missouri River running down the middle, as you can see, and then also the Mississippi coming down the east side of our state. I draw your attention to the blue in the middle. We have several man-made lakes in Missouri. Our Corps of Engineers have dammed several of our rivers and made lakes, and that's important to my talk today. You can see some of the yellow counties highlighted. That's what I'm going to talk about today. And here's maybe a better view of our counties by project. We wrote our first grant application in 2017 when I was the curator and the NAGPRA coordinator here at the museum. This was for a large collection that came into our control from reservoir projects. You can see the 7 pink counties here on the map. There are 64 sites in these 7 counties that have humans in them. And we had a wonderful consultant help us and to moderate our in-person consultation meeting that we held in Oklahoma in 2018. We had 18 tribes invited to attend, and we had 13 participate, and they are continuing to work with us. We learned a lot in this meeting, that they prefer for us to rehouse the individuals and the funerary objects into biodegradable materials. So as they're handled, then they're ready for physical transfer when the time comes, and they don't have to be handled any extra times. Also, they requested photos of the funerary objects that can aid us in determining cultural affiliation together at our consultation meetings. So with this knowledge, we carried this into our next grant, which is from the Powers Phase project, which is in the blue counties on the map. We accepted the transfer of this collection because it is from sites in southern Missouri. It was not excavated by our university, but you can see the blue counties. We did not know that NACPRA compliance had not been completed on this until we were inventorying the 99 boxes when they arrived here, and we found the individuals. We continued rehousing the individuals into biodegradable materials and photographing the funerary objects for these individuals as well during this grant. The last grant I'm to talk about is our 2020 grant, which is for the Missouri Archaeological Society collection. These individuals are housed in our facility, but we didn't control them at the time. But the transfer of control to us gave us the authority to consult on them. So we examined every box in the collections to be sure all individuals had been identified and moved to our secure NAGPRA room. Because these sites are from avocational archaeologists, the collections, they have varying levels of documentation. But we're able to digitize what we have in archives and finalize the site summaries. And we're working to share those with our consulting tribes. And we're going to consult on all this information this spring. So you can see in this slide, the 3 projects and how many individuals that came into our care, into our control, that we're able to, because of our grants, to digitize the information, get it to our tribes, and have meaningful consultations with our tribes. So out of these grants, we wrote the first draft of our traditional care and handling guidelines. We shared those with our tribes, and that will change and be updated as tribes have new information. They asked us to rehouse, which we hadn't thought of. And so everything has been rehoused up to now for our grant, and we'll continue that work going forward. And then also to see the funerary objects without having to travel. So taking photos and be able to share those with our tribes digitally through thumb drives and things so that they may look at them and we can determine the cultural affiliations together. So these grants have made all the difference in gathering the documentation so we can consult with our partners. Our goal is to return the ancestors and funerary objects in our care, not just these that these grants are covering that I've told you about today, but all of the ancestors that are in our care. So that's what we're working on. We do have a culturally unidentifiable inventory that's been submitted on other things, but we're working through all of those. And we think now that we will be able to culturally affiliate almost all of the ancestors that are in our care here at the University of Missouri. I just wanted to thank you and give information. If any tribe has any information, this is how you can find me, and it's on our website. Thank you very much.
Candace, thank you very much. That's an interesting set of information. Can I ask a couple questions?
Absolutely.
You mentioned the different grants that the projects were made possible by. Were those NAGPRA grants? Were those NAGPRA, National NAGPRA grants?
National NAGPRA consultation and documentation grants, absolutely.
Okay, terrific, great, great. And you mentioned, you showed actually a document that was developed with the tribes for treatment and handling, I believe it was called. We've had some discussion about the proposed revised regulation revisions, and one of the new sections there would be a definition for the kind of care that NAGPRA collections were afforded within museums or other repositories. I wonder if you'd be willing to share with us that document as just a matter of, a comparative point that we could take a look at that might have some information that would be useful more generally.
Absolutely. I attended the Repatriation conference last fall, and I saw some documents that were much better than mine. And so we've been revising ours because there are even things I hadn't thought of. And so it's really helpful that we can all get together and share that information and make ours stronger and better.
Great. Well, thank you. Thank you very much for that. Other review committee members maybe have some comments or questions as well. I guess I don't see any hands raised, although I can't see John. No, John, you do. Go ahead, please.
Yes, I just want to thank you for your presentation, this update. It sounds like to me, it sounds like there's lots of good work and lots of things have been accomplished, particularly with the use of the NAGPRA grants, and then the way they've been applied to moving forward with not just the collection care, but working with the tribes and the documentation. At least for me anyway, that's why I'd like to. It all sounds very positive to me, and I want to commend you on that, and commend you on the way you've been working with the tribes, and I certainly hope that continues in the future. So thank you for that update and presentation.
Thank you.
Thanks, John.
I wonder if I might ask a question.
Yes, please.
Candy, you mentioned that many of the ancestors in your care, you believe will be able to be culturally affiliated, although they have in the past been culturally unidentifiable.
Yes, they were submitted before I got here as CUI, and since I've learned more and talking with our tribes, I think that we'll need to update and we'll be able to change that.
I wondered if you could pinpoint, generalize. I know it's hard given the amount of detail you must have, but what is allowing you to make that new determination of cultural affiliation?
I think just talking with the tribes, I think our inventories were sent out earlier and they weren't followed up as well as they could have been. And learning, as archaeologists, we learn, about prehistory, about early pre-contact. And so we don't learn about tribes, and I am an archaeologist, and we don't have names. We just say Mississippian, which I'm, learning. There were people here. Now I don't know what tribes were here in the archaic period, but I know who was here historically, and hearing from your work and the repatriation conferences, that's enough, and having a geographic location is enough to be able to move forward. And I think that's really helped us to realize we need to go back and work through those.
Thank you very much.
I guess I have a follow-up question on that as well, if I may. You mentioned the geographical location, but you also mentioned time when you talked about the archaic materials from the archaic, which is further back in time, certainly than the historic period or just the proto-historic period in the state. So that still is something that needs to be taken into account. Would you agree?
Yes, absolutely. I think that I'm at a university, and I think that we need to add training to our students who are our future NAGPRA practitioners to teach them how to look at historic documents and how could you go about deciding. And it's not in a book and it's not in the ground, but you need to look at the objects and see if you can see what tribes it might be.
Mm-hmm.
If the goal is to return everybody and not just return what you figured out for sure, because we have the preponderance of
Right.
evidence. It doesn't have to be 100% for sure. So
Right.
Teaching that, I think, is really helpful, and the NAGPRA trainings are very helpful.
So when you're consulting with tribes, you're obviously consulting with the tribes currently in the area, but how do you go beyond that to take into account the fact that other groups might have moved into what's now the state and out of the state, and that, the sort of things with people moving around in ancient times?
I don't have a way for that. So I know the historic tribes, and then I also know Trail of Tears, some tribes moved through. And so the tribes, a lot of tribes have specific counties. They want to know anything happening in that county, especially if it's later. And so I just provide them the information and they let me know if they're interested or not, based on if I have a time period. And sometimes, we don't have a time period. If it's just, a single tooth with no objects, I don't have a time period. So sometimes we work through that as well.
Thank you. Thank you very much. John, you have a comment or question again?
Yes, I have a follow-up to both you and Melanie's comments. Particularly the question, or I think that you, in some of your answers, you had said that how you've gone back and you've sort of, I guess you're updating the consultation process, and you're reviewing the records. And I know we're starting to, have started to hear or see some comments about how the new proposed regulations might impact that. But the new regulations, proposed regulations aside, I think what you pointed out, and I think that others out there who are attending, I think this is a good learning or a teaching point here to say that although initial consultations might have taken place 20 plus, even close to 30 years ago now, it's certainly very important to revisit those, particularly those, even when those initial sort of inventories or contacts went out, particularly when you're revisiting these collections and not just, solely base it upon those initial, like I said, that initial research and consultation that took place that long ago. As you've certainly mentioned in your responses, and at least I took it from part of your presentation. I mean, that this is important things. We learn certain things over time, but also you learn to the extent that how the tribes are participating, their sort of their answers in this, or their, I guess, the importance of once again the importance of consultation. It sounds like you're learning, certainly learning a lot, and I think we all stand to learn a lot from those. I want to say like what we had learned stereotypically in the history about these areas. But I think that's important. I think it's important to build upon that, particularly that research, because we can certainly learn a lot from that, and it's certainly important in this day and age as we're moving forward with these collections. And the second thing the point I wanted to comment on is that you mentioned about students and practitioners and how you came through the archaeology programs and students learning about these things. I myself came through certain programs like that, and it's I don't know. I thought even that, I hate to say that long ago, but even 20 plus years ago, my early sort of learning in this process is I always thought that from that point forward, I always thought that particularly if you were going into archaeological research or museum work, at that point, I always thought that at some point, or repatriation would be like a learning, I don't say learning module, but something that's a part of that component that you learn, since it's always going to be there and present. But what I've discovered is that perhaps it isn't in some of these programs. And I want to really commend you for saying that it is important and it should be a part of like the students' learning process. I thought it always would be, particularly as you're moving forward particularly if you're going to be working in certain aspects of archaeology or museum work. I don't know if I just naively assumed that 20 plus years ago that people going into those fields would be a component of their learning process. Once again, I want to thank you for that comment and stressing the importance of that. So thank you.
Thank you.
Thanks, John. Other committee members, any questions or comments? Well, if not, Dr. Saul, thank you very much. I guess we need to move on to the next order of business. We appreciate you taking the time to do the presentation, and we're glad to hear that the implementation of NAGPRA at your museum is moving along, and you're doing some good things, it looks like. So thank you for that.
Thank you so much.
The second item on the agenda today is a time for public comment. Every meeting of the review committee includes time for public comment, as is required under FACA. Within the scope of NAGPRA, the review committee is particularly interested in receiving public comment on the progress made and barriers encountered in implementing repatriation activities under the law. If you're interested in making a public comment during this meeting or at future meetings, you can raise your hand or send a chat to request to make public comment. The review committee can also accept written comment, and that can be submitted directly to me at nagpra_info@nps.gov. We did have one request for public comment already, and that is from Valerie Grussing. She is the Executive Director for the National Association of Tribal Historic Preservation Officers. Valerie, you should be able to turn on your video and audio. There you are.
Hello, everyone. It's nice to be here today. Thank you for the opportunity. As Melanie said, Valerie Grussing, I'm the Executive Director of the National Association of Tribal Historic Preservation Officers, that's NAFPO, based in Washington, D.C. This is my home office in Silver Spring, Maryland, on the north side. DC, it's the ancestral homeland of the Piscataway and the Nacotchtank peoples. And as a descendant of colonizers myself, I, as always, am eternally grateful for the opportunity to do this work and to speak here with you today. NAFPO is the only nationalist organization devoted to supporting tribal historic preservation programs. Founded in 1998, it's a 501c3 nonprofit membership association of tribal government officials who implement federal and tribal preservation laws. NAFPO provides guidance to preservation officials, elected representatives, and the public about national historic preservation legislation, policies, and regulations. NAFPO promotes tribal sovereignty, develops partnerships, and advocates for tribes and governmental activities on preservation issues. The Senate Committee on Indian Affairs invited NAFPO to testify on actions the Congress can take to improve NAGPRA in its February 2nd oversight hearing, The Long Journey Home, Advancing the Native American Graves Protection and Repatriation Act's promise after 30 years of practice. It was an incredibly humbling opportunity that I was so honored and grateful to have to advocate for necessary changes to help bring ancestors home. So I wanted to bring this to this committee's attention, our written testimony, which I believe Melanie sent to you and can also be found on the Senate Committee on Indian Affairs page on the hearing as well. And that includes requests for 6 amendments in particular, and for 3 evaluations by the Government Accountability Office. And I just wanted to run through those very quickly. The first being that NAFPO recommends an amendment to NAGPRA's definition of Native American, of course. And then number 2, regarding ownership, we recommend amending the provision regarding the basis for determining Aboriginal lands. And then related to that, the first GAO report we would like to see is for GAO to complete an evaluation of federal agency compliance with the requirements of this provision. That's 3002, and its implementing regulations, particularly focusing on consultation, completion of plans of action and comprehensive agreements, publication of notice of intended disposition, and the disposition of so-called unclaimed cultural items. The third amendment regarding repatriation of cultural items, we request an amendment of this provision to explicitly require that human remains and associated funerary objects be returned together. And then related to this, the second GAO report, we would like to see an evaluation of the implementation of the civil enforcement provisions of NAGPRA and its implementing regulations. Number 4, regarding illegal trafficking in Native American human remains and cultural items, we request an amendment to this provision requiring the government to show beyond a reasonable doubt that trafficked human remains and other cultural items were obtained without right of possession. And to further address this problem of illegal trafficking of Native American human remains and cultural items, we request the committee to establish and fund an interagency investigative effort like the Four Corners ARPA task force. And this was a request we made of the Senate committee, to be clear. And we also request that the Senate pass the STOP Act, of course. Number 5, we support the redelegation of enforcement and other activities to the Office of the Assistant Secretary for Indian Affairs as proposed in the 2020 Holland-Rokita bill, which may either be accomplished through a secretarial order or failing that amendment of the statute. Our third GAO report we would like to see. We are concerned about the effectiveness of the NAGPRA grant program in general terms, and we request an evaluation of that, leading towards suggestions as to how they may be most effectively used or restructured as needed to maximize repatriation. And finally, not a NAGPRA amendment per se, but related. This is number 6. We recommend and amendment to the NMAI Act that would enable Indian tribes to challenge the failure to repatriate cultural items in the United States district courts as they can under NAGPRA. So that's it. We ask the committee to consider these proposed amendments and evaluations and preparing its report to Congress for fiscal year 22. And thank you for this opportunity today and for all that you do.
Valerie, thank you very much for that quick summary and for providing the written version as well that we can study and take into account as we're working on our comments to the Secretary on the proposed regulatory revisions and on the our annual report to Congress as well. I wonder if any review committee members have questions or comments on this.
Frank, I do.
Go ahead, Honor, please.
Hi, Valerie. Thank you very much for your presentation. I was especially interested in hearing, we received your written testimony. It was very telling, the graphic entitled Completed NAGPRA Trafficking Cases Between 1990 and 2021. Could you take a moment to go over that for the review committee?
Sorry, you're referring to, and this is in the full written testimony on page.
Let me see if I can find the page number. Were there page numbers
No,
on
there's
here?
not page number on here. Sorry about that.
It's about, I would say,
Six.
2/3 the way down.
Yeah.
Yep.
It's page 6 of 8 here. So yeah, I would, if you have that in front of you, thanks, Honor, for your question. I'm not sure how much I can explain about this that's not in the graph here. As you can see in the text above that, Dr. Timothy McEwen, you all know and love, actually serves as our repatriation advisor here at NAFPO on a pro bono basis, which is totally separate from his responsibilities on the review committee. And this is based on data that he has compiled into this graph here. And if you have specific questions that aren't answered in the text, maybe we can talk offline.
Honor, does that give you an answer?
Sure. I mean, what I was most interested in was what seems to be over the past 11 years in the graph, and in particular, since 2017, I'm not seeing that there were many prosecutions on failure to comply. And I think Tim's here, and maybe Valerie could comment a little bit on that, on what they found in the data.
I'm not sure if Tim wants to comment on, he does not. Getting back to the issue of separate hats here, that is indeed a trend, and that's a really important observation about this graph. And I think some of the changes that we are requesting both to the statute and in our longer comment letter on the proposed draft changes to the regulations as well would help try to address that troubling trend.
Excuse me, can I just clarify? I thought we were talking about the graph on trafficking, the criminal violations under NAGPRA, but Honor, when you were asking your question, you mentioned failure to comply, which is the civil enforcement. So I just want to clarify which graph we're looking at. There's a table related to civil enforcement in the testimony, and then there's a bar chart that talks about trafficking under 18 US Code 1170, that the criminal provisions of NAGPRO. Which one are we talking about?
Actually, Melanie, maybe you could bring both of them up so that the rest of the review committee could see it.
Well, I can bring up the document. I'm not sure I can put them both on the screen at the same time. I did put a link to the document in the chat. One is on page 5, the other is on page 6 of the document. Can you see that?
Yes, I think so. I can. I'm not sure the others. This is the trafficking case, it's obviously from the heading.
Oh, yes, this was very informative to me. Valerie, maybe you could go over this graphic just a little bit for the review committee.
Sure. Well, I think the most important trend, as you point out, is the steep decline in recent years. And on a personal note, I have been here at NAFPO since the beginning of 2019. So the extent of my personal knowledge is limited as to the beginning of this trend. But I'm not sure how far I want to go into speculating on causes in this setting, but yeah, I think we can talk more offline.
Okay.
I have a little comment about this because it seems to me when NAGPRA was first passed, the U.S. attorney's offices, which by that time had a number of them had, not all of them, but a number of them had obtained various kinds of professional training about the protection of archaeological resources under ARPA and the Antiquities Act, and well, those two primarily, some other acts as well, looked at the trafficking provisions in anti-trafficking provisions rather in NAGPRA as another law, another statute they could use in their prosecutions of people that were obviously violating NAGPRA, but also violating ARPA and some of these other laws as well. And I'm not sure that the kinds of professional training that was being offered in those earlier years, it has actually continued at the same kind of pace that it was at then. That there's been a kind of a slacking off of that kind of professional training, which the Park Service was both sponsored and conducted in cooperation with the Department of Justice. I don't know whether anybody, Valerie, yourself, or any of the other members of the committee, or Madam DFO has any sense of that, whether what we're seeing there in that in the most recent years, and might be an indication that the Park Service might want to increase its ability to provide that kind of professional training and work cooperatively with justice on it. I wonder if you've been involved in any discussions along those lines, or am I just surmising from some casual comments that I've heard about the fall off in the professional training?
In general terms, I think it's pretty safe to say that there's always room for improvement in training of federal agency staff related to this specifically. But across the board, this is something that we see with regard to consultation in pretty general terms as well. I think, Tim, you did want to comment.
Sure. Just in terms of the background for this particular chart, the information was all obtained from two primary sources. One, the Executive Office of the United States Attorney's database of all of their criminal cases. And then secondly, follow up with PACER and other document search sorts of mechanisms to identify individual cases. I think you're correct, Frank. There is a training issue that's evident in here as well. But if you look at the chart, in particular, the cases that are shown in yellow, these are the ones that are related to illegal trafficking of sacred objects and objects of cultural patrimony. All of these cases all these convictions were done in either New Mexico or Arizona. And while the ARPA task force was only in existence for a couple of years, most of these cases were all done by former members of the ARPA task force. So once they had gotten together and were working together, they continued to do so until about 2005, 2006, when a number of them started to retire. And that capability to do that kind of work, particularly focused on the Southwest, has not really been continued over time. I think in part because of the financial issues in terms of having a interagency kind of enforcement mechanism like the ARPA task force provided for. And then the Park Service picked that up in terms of their resource protection efforts as well. And then secondly, I think with DOJ in terms of their training, which seems to be less fulsome than it was back in that period.
Thank you. Thanks, Tim, for that perspective. So there's something to this perhaps, and Valerie, you as well for your comment on that. Other comments? Anybody from the review committee members?
Frank, just one more.
Yes, go ahead, Honor, please.
Looking at that chart again, if we could pull it up. Melanie. It's looking like on average, there's less than 5, certainly less than 3, almost every year consistently. Which seems hugely problematic.
If I could just note that while this information is in the NATHPO testimony and should be considered by the committee in development of your report to Congress, this area of NAGPRA is well outside the purview of the review committee's responsibilities. I wouldn't want you to expend too much of your time delving into this issue. If what you're wanting to do is perhaps develop a recommendation to Congress for your next report, I would suggest that you refer this to the subcommittee on the report to Congress to develop some kind of relevant recommendation.
I think that's a reasonable suggestion, Madam DFO. But if there are any other comments quickly, since we've started a little bit of it, why don't we give the committee members an opportunity? Otherwise, if not, we can thank Ms. Grussing and move on to the next item. I have one question, Tim. Again, this is for you because you put the chart together. The the unfilled in space in the bars, the blank space, basically a white space, that indicates that there was some information that the U.S. Attorney's Office received about a possible case, but they chose not to pursue it. Is that correct? Is that a correct reading?
That's correct. That means that documentation was provided by the law enforcement agency to DOJ, but DOJ, for a variety of reasons, has decided in those particular cases not to proceed with a criminal prosecution. In some cases, they determined the evidence was not sufficient to show criminal intent, or that the evidence was not sufficient to show all the other elements. Sometimes it's that it just doesn't fit with what their priorities are. The good thing about DOJ is whenever they make the decision not to decline, they have to say why. So there's evidence, there's documentation on that.
Okay, that might be interesting to look at as well. Thanks, Tim.
I'm working on it.
Any other comments? I don't see any hands up. Barnaby, I can't see yours. John? Yes. John, go ahead.
Okay, yeah, just one quick comment. I want to thank you for your sending this to the review committee and for your comments today. And just as I'm reading this, so we're clear. So your recommendations or suggestions, they seem like a combination of considerations for both the proposed regulations and some pieces of the legislation as it currently exists. Am I correct in reading your recommendations?
That's right.
Thank you. Thanks, Valerie.
Is that a?
That was a yes.
Was that a yes?
Yes.
Okay. All right.
Thank you, Valerie. Thanks, John. Honor, you started this conversation and you talked about the table in the report, which deals with the civil penalties, or the civil side of the act, which I think the review committee would have some responsibility for engaging in. Do you have any further questions about that? Because we didn't really look at that. And if not, that's fine, but I just didn't want to close off the discussion if you had your full information you were interested in.
Yeah, I wanted to make sure everyone was on the same page. Maybe, I know Melanie was talking about that. Could we bring that portion up? I just wanted to make sure I'm looking at the correct documents.
Sorry, just a minute, having a technical issue here. I want to be very clear for the record that I'm sharing the NATHPO testimony. And this is a NATHPO document. So I want to be very clear about what is being shared here. Is the link is in the website, it's in the chat. I would encourage people to be sure that they're looking at the full document.
That's it.
And I would just further remind the committee that your responsibilities are for sections 5, 6, and 7 of the Act, which cover the inventory and summary provisions, as well as with the repatriation provisions. Civil enforcement under NAGPRA is the responsibility of the Secretary of the Interior.
Thanks. I was hoping that Valerie could explain this chart a little bit more as well to the review committee.
Sure. Like I said, I don't have personal knowledge of the background behind these things, but the data shows that failures to comply have not been determined since 2016, 2017. And so that's why we were hoping that GAO might be able to take a closer look at some of the reasons behind that.
Thanks, Valerie. It seems like there's also a very low number here as well.
Thanks. Thank you, Honor. Any other comments or questions by committee members? John, go ahead.
Yes, back to the going back to some comments, particularly about the culturally unidentifiable, but also associated funerary objects. But I was wondering, while these are your recommendations, do you have any thoughts on unassociated funerary objects at all? As a part of these your recommendations?
I wouldn't pontificate on that here.
Okay, thank you.
Valerie, thank you very much for sending your written comments to the to the Senate, so that the review committee has the opportunity to take a look at those as we're working on comments back on the draft proposed revision. So we appreciate you having that, and also for your presentation here to give us a little more detail and background on that document.
Sure. Thanks very much.
Okay.
We have received a comment in the chat, and I was asked to read it for the record. The chat is misidentified, and the comments are from Angela Garcia-Lewis. And her comments are thanking Ms. Saul for the University of Missouri for the presentation. The comment is, I think it needs to be emphasized that the affiliation was made possible through diligence and good communication / consultation with tribes in the area. That is in response to the discussion on cultural affiliation of those collections at the University of Missouri. Furthermore, Angela Garcia-Lewis added that another comment related to the discussion on training. I think existing training for federal employees needs to emphasize that the end goal of NAGPRA is the protection and timely repatriation. I feel that training is focused on recovering burials rather than relationships between NAGPRA and NHPA and utilizing the no-build alternative for burial protection. And again, that was Angela Garcia-Lewis who asked me to read her written chat comments for the record.
Angela, thank you very much for those comments.
We have no other requests at this time for public comment. Again, you can raise your hand or put your name in the chat. We will have a second opportunity for public comment as the fourth agenda item today. Mr. Chair, I have no other public comment requests at this time.
Okay, thank you, Madam DFO. Well, then I think if the committee is amenable to this, we should move on to the next item, which is to continue our discussion of the 2021 draft of the proposed regulatory revisions. Just as a update, the committee did develop a set of comments and for the Secretary of the Interior, requesting a number of actions on her part. And the letter that transmits those recommendations is now at the National NAGPRA office. And Melanie has informed us that she would transmit that to the Secretary herself. Is there any more on that, Melanie? Does it have to go through a cascade of other offices to get to the Secretary, or do you carry it up and turn it over to her?
Well, given that we are still in a maximum telework, there won't be much carrying right now, but no, we have an electronic system through which all incoming correspondence is recorded, and I have sent that to the controlled correspondence office to enter and to route to the Secretary.
Okay. Thank you. Thank you very much. And thanks to the review committee members for going through the process of developing those requests and comments to the Secretary, focusing on the general nature of our concerns and asking for her to do certain things to, we think would improve the procedures and the process for actually develop the changes to the regs and making the implementation more effective. So thank you for that. Does anybody have any comments on that in particular? If not, I'd suggest we turn our attention back to, I think the document that we were working on is February 11th, dated February 11th, and it's the 22-page or so document that lists systematically going through the sections of the proposed revisions and looking at them sort of piece by piece. If committee members don't object, why don't we try to do that? I hope each of you has been able to rediscover that document. It took me a little while on my computer files, but I think I found it. And I believe we got through the first 5 pages. Page 5 at the very bottom are comments about duty of care, which we actually put together and we have that down on paper. So we don't need to continue the discussion there. I think our next comment would be at the top of page 6, 10.1 introduction. The delivery and the timelines. This is kind of an administrative matter, but I guess our comment to the Park Service is putting these sorts of requirements about days to do this and method of transmission and things like that might make it more difficult in the future to change those things. It's a more difficult administrative task. Madam DFO, you had a reason for doing that. Do you want to explain what that is, or is this not a problem? Administratively, I mean, not this isn't really policy here. It's more administration. I don't think we want to spend too much time on it, but.
I'm not prepared right now to explain the purpose behind these provisions beyond it was noted as being an area of concern in how standardizing how documents are transmitted.
Okay, well, perhaps, and I understand that that's a reasonable response. Perhaps you could sort of go back and refresh your memory or talk to the staff about that and just determine whether that is something that would be onerous in the future when a new method of delivery or a new time frame needed to be imposed. You wouldn't want to have to go through the whole regulatory process to do that. It may be that it can be done easier administratively.
I'm sorry, are you suggesting that in the future, there may be an alternative to email or
Something like that,
physical
or
delivery, and that's your
I
concern?
mean, yeah, as we find ourselves now in the present, 10 years ago, we had a certain way of doing things, of getting material and noting when they arrived and all of that sort of thing. And that has been changed substantially just by technological developments, not any new policy or a procedure or anything like that. But if you if you bake it into a regulation, unless there's a relatively easy way to modify it at some point, 5 years out, 10 years out, whatever, you might find yourself sort of saddled with a set of procedures that everybody, that don't work anymore, even on computers, right? That you don't ask people to send a CD anymore, for example. But that's
Well,
all.
we would certainly welcome input from the public on that issue, especially as it relates to other methods by which written communication may occur.
Okay, thank you. The next
Frank,
I'm sorry, Tim. Go ahead.
if I could make a recommendation, we had, I think, put in 2 kind of new proposals, not at the last meeting, but at the one before, that were sort of at the top of 10.1. And I don't know if we had sort of resolved those yet.
Okay. The
So-
new text for duty of care and
Yeah,
purpose.
so I would recommend that as we go through this, we'll just start at 10.1A. And if there's an issue there, we resolve it. And if not, we move on to B.
Okay, well,
Because I think what the discussion I think that we had last was we had some discussion about the language in the current rule for purpose, and then the revision in the draft proposal. And then the new thing that came in was what Congress said the purpose was.
right.
And I don't know if we've resolved how to deal with that yet,
Okay.
what our recommendation is.
Okay. Okay, then we can go back to that, step back to that. I had the sense, and this is maybe just in my memory of it, which isn't the only thing we need to rely on, that we had more or less agreed that we would use the purpose text from, I think, the House report, and then we would use a text that I think Shelby might have suggested, or maybe it was one of the other members, on duty of care, but we can go back and revisit both of those. I don't actually have that particular document right here on my screen, so if somebody else does, maybe we could look at. Those were at the very bottom of the document that we did review with the general comments on it. I was assuming we just sort of take that as the beginning point of our continued discussion on specifics, but we should go back and make sure everybody's comfortable with those substitutions.
I mean, can we have a discussion about whether we should focus on what Congress said the purpose of the statute was vis-a-vis some other text?
Sure. You want to lead that, or take the first shot at that comment?
Sure. I like to go back to see what Congress said about things and
Sure.
what the statutory language is. So my
Thank you,
preference actually-
Melanie. Thanks for putting that up. I think it was Melanie that did that.
Yeah.
Yeah. So here's where we are with these 2 subsections. So if we all agreed with this particular text, we would be recommending a change in how purpose is described in the regulations, substituting what turns out to be the text that was in the House report on the legislation for the text that's currently in the 2001 draft proposal for revisions. So committee members, what do you think? Is this, do we want to recommend this as a better text? Or something different? Or what's in the 2021 draft? I can't see Shelby. If you've got Shelby or Barnaby, if you've got a comment, go ahead and make it. I can't actually see whether you have a hand up.
I don't have any comments, Frank. I think my original comment way back when we started working on this was just that NAGPRA regulations are to implement the law, and I think it's stated in here well enough. I think that.
Okay, so you would advocate for the substituting this text that we're looking at now for what's in the draft proposed 2021 version?
Yes, I think the wording in the draft as it stands right now is pretty vague. And my concern is, a lot of us who have been working with this for 30 years, there are going to be a lot of new people coming along who may not have the specific training that we've just been talking about today. And they need to know what this law is all about.
Okay.
Thank you.
Okay, thanks, Shelby. Well, let me then ask if are there any members that would like to see something different from what's proposed on the screen right now in terms of the purpose section, or are we all agreed that this text that we've proposed, which is again taken from the House report, is what we would recommend for that section? The only member, I think, no, I can't see Honor or Barnaby. If either of you have a comment, could you go ahead and make it? If you don't, if you agree with the new text, that's fine. Barnaby, I can see you now. Do you have a comment?
Yeah, I'm not sure. It's just a general comment. Through the years since the enactment of NAGPRA, tribes have always said that the title doesn't really, it's not realistic to say the purpose to protect Native American burial sites, because that never happens. Burial sites are identified in projects and the development NAGPRA plans of actions for removal, desecration of burials in these projects, that they don't avoid them. So the act does not protect burial sites. That's the sad reality of NAGPRA. Even though it says that, there's no time, all the years that I've worked with NAGPRA, that this ever happened where a project entity would say, what is cemetery, ancestral cemetery, or we'll go ahead and move the road over. No, they won't. They'll go straight through the cemetery. But in that process, they'll have that, what would I call it, that plan on how to attend to removal and repatriation of ancestors. So I just don't agree with that statement, that very statement in the beginning. And although each tribe is different, traditional religious beliefs and understanding, I personally just don't see that human remains would not be reburied. On this last sentence, it says, or disposition, meaning that they're not going to be reburied. That's the way I interpret that. So I don't know. So rather than me agreeing with this, using this, I would say no. That's all.
Thanks, Barnaby. Do you think it might be that this particular statement, the protection of Native American burial sites and the removal of human remains, funerary objects, sacred objects, and objects of cultural patrimony, is the intent? So in at least some situations where there's not a compelling reason for disturbing the burial, that NAGPRA encourages or directs that they would not be disturbed. I understand. I understand completely what you're saying. That when you're looking at when there is a development project, a new road, a water treatment plant, something else, some other sort of modern infrastructure that a community or organization or even a tribe that may have a greater importance in the view of the present day individuals, not everybody, but maybe the people who are making the decision about that, and that can lead to removal and disturbance of the burial. Although I think with the statute now on public lands, at least, that the remains that were recovered would be turned over then to the affiliated tribe, lineal descendants or affiliated tribe, or the closest affiliated tribe, so that they wouldn't become part of a museum collection. So it seems to me that's an improvement, if not something that is perfectly and consistently the outcome of these sorts of situations. So I understand what you're saying, but I think what we're getting at here is what is the purpose. So, looking at purpose, things don't automatically happen. Then you may need to develop over time.
I don't know if that's a good question. Maybe somebody should do some research and find out throughout the country, but here in the Southwest in Arizona, it's never happened that I'm aware of.
Okay. Okay, well, thank you. Tim, yes, go ahead.
I agree with Barnaby on this one. I think for the past 30 years, the statute or the regulations and the implementation may not have lived up to the intent of the statute in terms of grave and burial site protection. But that gets us back to this statement. This statement is not some opinion about what the purpose of the statute is. It is the purpose. It's the committee that introduced this bill. So to the extent that the regulations and the implementation have not achieved the goal of protecting Native American burial sites, that's something I think we need to pay attention to as we're reviewing the regs.
Thanks, Tim. Any other comments on this particular? Section? If not, then I think my sense is that most of the members understanding the problem of accomplishing what the purpose, in this particular instance, what the purpose of the statute is, regardless of that difficulty. And again, it's imperfect application in every situation. We are closer to the sort of a fuller description of what, again, as Tim said, what the legislators who eventually voted to make NAGPRA law saw as the purpose of it. And that, I think, might be a better way of describing purpose, at least than we had in the draft, the 2021 draft. If there's general agreement on that, maybe we could leave this for now, and we can come back around on these. And maybe we need to do that after we go through the full document and just sort of affirm again what we said at the beginning of our discussions. That would enable us to move on to the next section, which is the duty of care. And there was a definition there. Is okay, Barnaby? Would you be willing to accept that to move us along for our discussion?
Yes, that's fine.
Okay, thanks very much. Appreciate that.
If
Matt,
I
you have
might-
a comment.
If I might interject, I just want to note the time. We've been here together for just over an hour, almost an hour and a half. If the committee would like to take a break, this might be a good moment to do so.
I was actually going to run it to the midpoint of the hour, and then propose a break.
So a break in 10 minutes or so?
Yes, exactly. Yes. Okay,
Thank
we'll try that. Then maybe we can get duty of care taken care of, and we'll be ready to go on a little bit farther into the specific comments. Thank you, Madam DFO.
And Frank, I've got some comments on B, but I will defer those. Let's go to duty of care first.
Oh, okay. Sorry, Tim. I didn't realize there was another one. Okay. Well, again, this is the same situation we had, or a similar situation to what purpose. The duty of care as it was drafted in the 2021, I think several members felt it was confusing and in some ways confusing because it seemed to be very expansive, and in other ways that it seemed to be more limiting. So this particular definition for duty of care was derived, and I actually forget who suggested this particular text. Shelby, were you, Tim? You, okay. Well, maybe, Tim, then why don't you go ahead and say why you think this is better? And if the committee agrees, then we can go back to the point you made if we can do it in 10 minutes.
Sure. I think one of the concerns that a number of people expressed was the whole issue of relying on 36 CFR 79 as some gold standard. And obviously that I think is problematic for a number of different reasons. So I actually went back and I looked at some of the documentation that's provided by the American Alliance of Museums and how they define duty of care as a generic sort of concept. And that's the basis of that first sentence that I put there. I sort of NAGPRA-ized it up a little bit to have our specific focus. But the idea that that museums and federal agencies have an obligation to adhere to a standard of reasonable care while performing any act that would foreseeably harm any cultural item in their possession or control. And this is sort of a standard issue, particularly as it applies to this type of situation where with NAGPRA items, if they are culturally affiliated or geographically affiliated under the language in the draft proposal, basically a tribe can claim them immediately. They have the standing to make the claim for them. So basically, it's the duty of care that the museum or federal agency would have to make sure that no harm happens to one of these objects that another party, a tribe or a Native Hawaiian organization, is, except for the fact they've not made the claim, is the owner. So it's protecting the interest of the third party. And that's why I put that sentence in there about that they would need to consult with tribes to identify what they consider to be the duty of care.
Thanks, Jim. Any additional comments on this, what we're really proposing here is a substitution?
I have, I just want to say that we have some instances where multiple tribes claim affiliation with prehistoric ancestors, and they have different individual, desires or practices that they wish to be applied to how ancestors are attended to. So it might cause some, what I call disagreement between the tribes. And that's the reality again of NAGPRA, when we have these multiple tribes claiming affiliation with one ancestral group, then there's conflict about what needs to be done and how things should be done. So it's a challenge to try to get everybody on the same page. So I don't know to say what the statement paragraph says sounds reasonable, but ideally it's just not, it doesn't seem that, to me, it's not going to work. Even though I know that we deal with museums and they've always been able to honor our requests and attending to the ancestors upon consultation with our communities. So I know that that's good on their part and everything works out okay. But like I said, there are less instances that do occur.
Thank you, Barnaby. Those are good points. Shelby, you got your hand up, and then John.
I think John was before me, so go ahead, John.
Oh,
Sorry. Go ahead, John.
thank you,
Thank
Shelby.
you.
And we're probably going to say the same thing, I'm assuming. When I see this, and I go back to the proposed draft version, I'm trying to recall some of our previous discussions when we were starting this, but I think we have two different, I'm wondering if this is trying to accomplish two different things. Yeah. One, establishing a baseline of care. Then two is it sounds like we're having another discussion about one or two, the recommendations that tribes might have about those collections, whether they be NAGPRA related or not, about those the items in the collections. And so I think to get to I guess a part of that discussion, there's something that has to, there's the baseline. And I'm wondering if some of this discussion about duty of care, how this is being reintroduced or how this is introduced in the regs for this draft, is that we've certainly heard, or I mean, I've had occasion to hear where tribes have visited either museums or sort of like repositories or facilities, and they find that human remains or funerary objects, in this case, are stored like in boxes and paper bags that are falling apart, and just are not in really, what we consider like ideal curation sort of standards, I guess, if you will. So I'm wondering if on the front part of this, if that's what this definition is trying to address, followed by the second part, building upon that with the recommendations that the tribes have. If they come in and see, like I was saying just a few minutes ago, if they come in and see what they would I guess probably anyone would consider abhorrible or conditions, that's not that's not really what, that's not an ideal curation situation. And so I'm wondering if that part of the definition if that's what we're looking for or trying to address or wanting to address in duty of care. I think I had mentioned when we talked about this a few weeks ago, though, but to me, it's like when you are taking on the responsibility of caring for collections, there's a responsibility. There's a responsibility to that. And if the tribes come in and are upset, or anyone, whether we're talking about a tribal community or anyone their collections, I'm not just specifically speaking about tribes, even though this is what these regulations are about, but anyone comes in from a cultural community and sees their collections stored in what they would consider not ideal conditions. I mean, I think that there's a broad sort of duty of care while we're just focusing on tribes, but I'm just using like a broad example of that, everyone should be treated with due respect. I mean, I guess but my question is then is for duty of care, are we trying to at least one, establish a baseline, and then two, something to build on with the recommendations the tribes might have once you're at that, at least I don't want to say like I don't know if baseline is the right word, but something, some bar has to be, met in the care of these collections.
Thank you, John. Shelby?
Yes, thank you, John, and thank you, Frank. I think that one of the things that I was trying to stress before is that, museums do have, they do have responsibility because they are holding these, they have legal responsibilities because they're holding these collections in public trust. And so because of that, and I agree with John, some museums don't really have the most respectful ways of caring for these collections, especially when it comes to ancestral human remains and funerary objects. And so I think one of the things we could possibly, I'm not quite sure how to rephrase it, but the adherence of the high, of respectful standards of care and adherence to best practices as, as a way of protecting these collections or something. I'm trying to get my head to kind of figure out how to rephrase it so that I think there needs to be a term of respect included in this somewhere, because I think that's really important when it comes to museums and how they care for the ancestors and these sacred objects and objects of cultural patrimony and so on, and funerary objects. So anyway, I'm just trying, I'll see if I can wordsmith this a little bit and play around with it.
Thanks. Thank you, Shelby. Honor, go ahead.
Thank you. I appreciate the comments that have been made by the review committee members. Something when I heard John speaking about these two obligations that come forward in a duty of care that struck me is that there's a before there's cultural or geographical affiliation and an after in duty of care that maybe could be made more prevalent in our considerations of duty of care. I believe, John, you were talking about a baseline that needed to be followed, and then perhaps the ongoing duty of care once consultation was to happen would become would help to define what that duty of care must be going forward after or during consultation. And so I think we've all experienced the terrible circumstances of where our ancestors and cultural items have not been taken care of and might be haphazardly placed in boxes and can't be found in some instances. And what we're looking for, or what I'm looking for in this duty of care, and I think many others are, is that that's immediately respected, that there is that baseline that exists. And I think consultation is such an important part of understanding among the tribes what that ongoing duty of care is during that process. So in looking at this definition, you know, maybe that is a way of thinking about this. Thank you.
Thank you, Honor. John, go ahead.
Yeah, and I don't mean to say this in a somewhat combative tone, but I do want, I guess what I want to say or try to say is that if an institution or someplace is say they're not they have their that they're not pro repatriation, or that they're not sort of really engaged in that, but at the same time, there's I guess going back to what I was saying, there's a responsibility though. I mean, when you have whatever the collection is that's as they exist as a part of the collections, and if you have your apprehensions about the repatriation process, that shouldn't, to me anyway, that shouldn't sort of lower, I hate to say lower the bar again, but as that's reflected in the duty of, as it's reflected in the duty of care. And I wonder if some tribal nations or tribal representatives sort of, you know, in some ways might feel that way, is that particularly where there are great concerns about where the conditions of how, if we're just going to say archaeological collections, just as an example, I mean, is it enough to say, well, from a sort of a museum or a storage facility or whatever that is, like, well, it's not just that the Native American collections are stored this way. That's how we store all the archaeological collections. But I mean, is that enough of an answer? So I mean, when we get back to duty of care, and I think we've already started to hear some comments about, and Shelby made them too, about best practices and things, you know, and comments to speak to that, but. Again, I mean, she was also mentioned there are legal obligations, but there are also, as these institutions exist, I mean, there's a social contract, you know, between these places, these museums, the things that house these materials, and the greater public. So while I want to certainly focus on the duty of care as it sort of applies to what we're looking at here, it's a duty of care that really, in all actuality, should be applied to all collections. So I guess what I'm trying to get at is that everyone should be, or everyone's collections or how they're represented in these collections should be treated equally. And I'm wondering if that's in some ways that we're sort of getting at, although we're just looking specifically at Native American or tribal nations collections.
Honor, you have your hand up. We are past the time when we were going to go ahead and take a break. Do you have a quick comment, or do you want to come back?
No, I put my hand down. Thank you, John.
Thank you. I'll just quickly point out that I think maybe one of the issues here, and this is what John has brought up and Shelby as well, is that museums do have a set of standards that they're supposed to adhere to for how they care for collections. And maybe we need to cite that first, and then in addition say, as part of the duty of care for cultural items covered by NAGPRA, there are some additional things involving how specifically the treatment and the care is delivered, and that's based upon consultation with culturally affiliated tribes or lineal descendants or things like that. And that might be one way around the issue of what's the baseline for all collections, And we don't want to try to do that because that's not our job. What we're talking about is yet a higher standard that is specifically directed at cultural items that are being cared for in a museum or in an agency repository or something like that. So with that, Madam DFO, we are at about 36 after the hour. Why don't we take 10 minutes and come back at let's say we'll come back at 10 of the hour. Madam DFO is off my screen, so I can't see her, but she has her timer on. So you've got 10 minutes, everybody. See you when we all get back.
Okay, with the break time is over. Please turn your video back on. Okay, Mr. Chair. You should be able to see my screen still, hopefully.
Okay, Madam DFO, we're back.
Mr. Chair, I'll turn it back over to you.
Thank you, Madam DFO. So we've had some discussion now of duty of care and purpose. It seemed as if the duty of care that we had put together and talked about a few weeks ago, which is what you see on the screen, we may want to beef that up somewhat. Is that what I hear? And do I have one or a volunteer or two who would be willing to do that and bring it back to the committee next week, let's say, when we have our next meeting? Unless there's a way to craft it right now, but I'm not sure this is the right spot to try to do that. Shelby, I think you had mentioned you might be willing to do some wordsmithing. I think it was your term.
Yes, I would be willing to do that. And I would like to ask if John might be able to assist with it as well. And I would like to, I'll go ahead and draft something. And John, if you're willing to work with me, I will send it to you and we can go back and forth until we feel we've come up with something that's satisfactory to present to the committee.
Sure thing. That sounds like a plan, Shelby.
Okay, I hope you don't mind my
Oh,
volunteering.
no.
But I think you would be a great one to work with on this. So, okay, I will get something drafted in the next day or so and get that off to you.
Okay, terrific.
you.
Thank you. Thank you both very much. Okay, Tim, I think you said there was another 10.1B that you had some concerns about. I didn't actually see that in my copy of our 22-page document, but I could just be missing it. So do you want to start this next session or continue the session on the regs with that?
Sure. It actually wasn't in the document we did several weeks ago. It's
Okay.
as I looked at it.
Okay.
But I think this would be the place to do it. And I'll just throw the text there that we can discuss. This is an issue that I've raised before, and I think it's a place where under 10.1B, this would be a place where we could start by addressing it. And I'll just read that into the record. Under applicability, the Congress clearly required that museums and federal agencies prepare summaries and inventories of all cultural items in their, quote, possession or control, unquote. Removing possession requirement here is contrary to that purpose and is a clear abuse of discretion by the department. We need to stick to the precise statutory language unless there is some ambiguity, which I don't think exists here, or it yields an unconstitutional result, which again, I don't think applies here. So it's just a statement about a missing word.
Okay.
And when we get to the definition section, we can deal with it more fully, but this is the first place it comes up.
Okay. Okay.
And then continuing on, another issue related to 10.1B2. There's, I know that 10.1B2 was removed. There was a sentence removed, and that sentence says, these regulations apply to human remains, funerary objects, sacred objects, objects of cultural patrimony, which are indigenous to Alaska, Hawaii, and the continental United States, but not to the territories of the United States. And back at our July 21, 2021 meeting, I think Melanie said that that this is a paragraph that was often, that museums often had questions, and in the draft it's been removed, but I don't quite understand the reason. But my question about that is, does removing the sentence indicate that the department has concluded that NAGPRA does indeed apply to US territories, which if it says it doesn't in the regs and then you take the sentence out, you're sort of left with the conclusion that maybe it does. And in looking at the draft proposal, the issue of US territories is not addressed anywhere in there now. So that's just a question.
Okay. Madam DFO, do you want to try to answer that, or to call upon the interior solicitors who are with us to address it, if not answer it?
I will point out that the question at the end that you raised there, Tim, is addressed in the draft proposal by defining the United States in the definition section. And so then throughout the regulations uses the term United States to refer to what is defined there. I'm not prepared right now to discuss that provision or change in the regulations. I'm not sure that Brady or Stephen are either. We would certainly, though, encourage the review committee to make a recommendation to the secretary about the inclusion of that sentence or its removal.
Thank you, Madam DFO.
Brady has indicated he might want to chime in.
Okay.
I'll just add to what Melanie was saying, that I think the goal of this change was clarity. That's why the statement on this matter was added to another section of the regulations. It's not indicative of a substantive change.
Okay. Thank you, Brady. Tim, what do you suggest in that instance? Do we put a comment in and just put a question in, and then it could be addressed more fully once we finish with our, all of the requests and comments and recommendations that we're going to come up with as we work our way through this review.
Sure, and I've just put my question that I essentially read to you a moment ago in the text so that we have it right there.
All right.
So,
okay. Thank
you.
Thank you. Okay, so I think we agreed to leave the purpose text as it is, although we did recognize that might not be a complete, it might be something we want to come back to. Let's put it that way. Duty of care, John and Shelby are going to come up with something that is more broadly satisfactory from the committee's perspective. Tim's going to put in some questions about 10.1B and 10.1B2 regarding some definitional issues, so that those are highlighted. If then are we ready to continue to 10.2?
Sorry, I've got more.
Okay, which for 10.1?
10.1. This is for 10.1D, delivery of written documents. I note that in the last sentence of 10.1D2 states that any change of physical or electronic address will be noticed in the Federal Register within 5 business days. And I think our experience in terms of meeting notices, solicitation of nominations of new members in the Federal Register, and general publication of any notice indicating that this deadline of 5 business days is somewhat unrealistic.
Madam DFO, do you have a comment on that? This is sort of similar to, we talked briefly, very briefly about the how documents get delivered and the timeframes and things like that.
A change in the address for the National NAGPRA program. This is standard language from other regulatory texts that the department provided to include an address in the regulatory text itself for the National NAGPRA program, but to allow for possible changes to that.
Yeah, I'm fine with the change. I don't think 5 days is workable.
Well, again, this was what was recommended by other from other regulatory text. I will just add that other kinds of documents that you mentioned, Tim, those are documents that require approval by the department. Presumably, if there is a change to the address of the National NAGPRA program, the department will already be aware and have already approved it. So making a notice of that change in the Federal Register will not require additional approvals or review. It will merely be a procedural change. I would think it could occur pretty quickly.
Yeah, thank you, Madam DFO.
And then 10.1E, deadlines and timelines. This section calculates deadlines according to calendar days, but elsewhere in the draft, business days are used, particularly for excavations and discoveries. I think the statute refers only to days, so it doesn't make that distinction at all. And I would recommend that you develop one single standard and use it throughout.
Okay, that's another thing we can comment on. We don't need to resolve it right now, is it whether we prefer business or calendar. Other parts of this?
10.1G. The proposal highlights that the United States District Courts have jurisdiction over any action that any person alleging a violation of the act of this part, as reflected in 25 U.S.C. 3013, but it doesn't reflect the statute's recognition that the U.S. Courts of Federal Claims in resolving specific matters, as reflected in 25 U.S.C. 300113. I'd recommend that we revise this section to include specifically the federal court or the United States Court of Federal Claims jurisdiction for determining whether the use of right of possession in specific situations would result in a Fifth Amendment taking by the United States, in which event the right of possession would be as provided under otherwise applicable property law.
Okay, I'm not sure. I know I'm don't feel myself qualified to comment on that particular matter, but certainly we can highlight it as something for the department to review and determine whether they want to make that change or they think it's what they've got is proper and necessary.
I think we had discussed it at an early meeting, and I don't think anybody objected to that idea, but we didn't put it into the written document. So I just wanted to make sure it was still there.
Okay. Well, why don't
if I can just remind everyone, especially those in the audience, that there will be opportunity for any person to comment on the proposed regulation and the proposed changes. What the goal here is for the review committee as a whole, as advisors to the secretary, to develop its regulations, to develop its recommendations on these regulations. So I don't want the committee to feel like it needs to capture every possible comment. There will be opportunities for individuals, including those of you who serve on the review committee, to provide your comments as individuals. The review committee should be providing recommendations that it can agree on as a group based on its expertise and specifically based on the balance of membership in this committee.
Thank you, Madam DFO. So I agree with you that ultimately that will be the case, that anyone will be able to comment on it. And I think for these sorts of issues where maybe one or two committee members have particular expertise, we might just highlight this as a question or as an issue and not try to craft an alternative language or alternative terminology or whatever. So Tim, maybe you could put together a brief comment or a brief question with highlighting some of these matters, and then if we go forward with them, we can just advise the secretary that these might need to be looked at more, something of that sort. Would that satisfy by highlighting it?
Sure. And I'll just tick off some of the other ones that I can provide text on. We don't have to talk about them here. I think there's an issue with final agency action under 10.1H in terms of the various ones that are identified as being final agency actions. But of particular importance is this idea that there would be this statement of disposition or repatriation that would be done at the time that the objects were transferred. But there's no provision there that this is made public, that the only way this information is known is that the museum signs it and the tribe gets a copy of it, but no one else knows because it's not public. And in terms of final agency action, there needs to be some mechanism that anyone can appeal. And that gets to a second provision here, that there's a proposal that these final determinations are final and not appealable, even though they're not been made public. And in looking at the Code of Federal Regulations on what these are called irrevocable waivers, typically those attach only to affirmative actions by a party and not to mere inaction. And what we've got here is this irrevocable waiver is being attached to someone who didn't act and may not have known they had to act, which is inconsistent with the way that that concept is used in federal regulations anyway. So I can provide some text on that as well.
Okay. I think that's fine. Do any of the other committee members want to weigh in on those various sections that Tim just went through? Okay. If not, then Tim, you'll do that. That'll be great. So then I think the next section we wanted to look at is 10.2 definitions. And Shelby, why don't you lead off there? You had a question, I think, about the phrasing of definitions for this part.
Right. I wasn't clear, when it said definitions for this part, I wasn't clear on why the definitions were just referring to one part. And then we get later into the document and there are no definitions for certain things. And so I wanted some clarification on that. I think it should just be definitions as it is in the original regulations where it covers everything. And there were terms that were things that, like disposition statement is used in a lot of places, but there's really no definition of what a disposition statement is. I think it's making some assumptions that museums would know what a disposition statement is, or a federal agency would know what that is. So that was my concern.
So the concern there would be that a definition might be needed. That's not there.
Right. And
Okay.
so by saying it's just referring to this part and not to other parts of the document is kind of
It-
what I'm trying to get
Actually,
at.
the part is the whole thing. So part 10 is the entire regulation. So when the word part is used, it means the entire regulations. When the word section is used, it only refers to a specific portion of it. And then there's a intermediary, which is the subpart. So the biggest is the part, there's a subpart, and then there's sections, and then within sections are paragraphs. And that's a standard regulatory convention structure. So the definitions apply to the entire regulations.
Okay, I guess I just misunderstood. It sounded like it only was referring to just this particular introductory part. So, okay.
This is a
Hope everybody else understands.
little bit of inside information from people that write regulations about that. But your question about the other matter, that there might be need for a definition. Melanie, can you address that? Do you think that is a needed definition, or is that understood more broadly?
I think if the review committee feels like that's a needed definition, they should make that recommendation to the secretary.
Okay.
There's a definition for disposition, and there is an explanation of what a disposition statement or repatriation statement contains in the regulatory text.
Okay.
And I have a question about that statement. That statement would be the same type of statement for every aspect of the disposition.
In the draft text, disposition applies to items that are found on federal or tribal lands after November 16th, 1990, so only subpart B. Repatriation would refer to any item that is covered under subpart C from museum and federal agency holdings or collections.
Right, okay. All right, when we get to that section, I might have a few more questions.
Okay. All right. Thank you. Also then beginning at the front end of the definitions, 10.2 section. Tim, you had a question about, or a recommendation really about some wording. Do you want to go over that, or do we just want to leave this in as a comment that we have?
I think what I wrote there is pretty straightforward. If anybody has an issue with it, we can chat about it, but it's just about how to use English.
Okay. All right. We'll leave it at that, if that, unless other members have a comment.
Melanie, could you bring the document back up again, just so we're following as we read?
I'm sorry, you want me to bring up the 22-page document that has everybody's?
Yes, I think that's what
Filed.
she's asking for.
Okay, I had.
As we work our way through. If you could, that'd be
I
great.
don't think yes, give me a minute to pull that one up.
Sure. Okay. Okay, I think. All right, we've gone through 2.2, the first two 2.2s. I'm sorry, 10.2. Acknowledged Aboriginal land. Tim, you had a comment about the first subpoint in the definition.
Sure. Let me see if I can find that.
Yeah, that comment actually goes on to the next page, but I don't think you can show that page. If you could show the top part and continuing for the first few lines of the second, but I think the software just doesn't allow that. So
Give me a second, I can find it here.
this relates to treaties as a source of information about acknowledged Aboriginal land.
So the first subpoint in the definition of acknowledged Aboriginal land includes, quote, a treaty sent by the President of the United States Congress Senate for ratification. Transmission from the President to the Senate is just one of several decision points along the path of a treaty. And in order to interpret this provision in a way that is most beneficial to tribes, we might consider requesting to revise the first subpoint to read a treaty signed by the US Commissioner or representative and one or more tribal representatives, which would be the first case where there was an agreement between parties regarding Aboriginal land.
But this treaty, that was the first, as you said, was the first step. I'm guessing, I'm inferring now from some knowledge about how treaties are dealt with. The treaty that was signed, the document that was signed by the commissioner and the tribal representatives, in some instances would not have been accepted by the president or might have been rejected by the Senate.
I think the ones in play are the ones that are of concern are the ones that were not affirmed by the Senate. And I think the definition that has been proposed here by the department would get around that issue by saying they don't have to be affirmed by the Senate. They only have to have been transferred for consideration, transferred to the White House to be sent to the Senate. And if we're gonna, and I think that that's a good thing. I think that that's a good move. But my point is, if we're gonna cut it back a step, why don't we just go back to the first step? Where there's a meeting of minds between a representative of the United States and Indian tribes regarding land and what constitutes the Aboriginal land of a particular tribe. And whether that agreement gets affirmed by the Senate or not is kind of irrelevant. The agreement was made and people made decisions based on that.
Any comments by review committee members on this?
So we're not considering the Indian Claims Commission's identification of Aboriginal lands. This is might be something that would apply to Eastern tribes. Here in the west side, like for us, we're not a treaty tribe. We never entered into a treaty of any kind with the government. So, I mean, it's not a universal statement. So it would only apply to some tribes, but not all the tribes. When I say Aboriginal territory with the Indian Claims Commission, that's something that happened where, you know, like for instance, our tribe presented evidence of Aboriginal territory at 3.8 million acres beyond present day community lands. And they reduced it for their final judgment or designation of Aboriginal land. So even that designation is still doesn't encompass our total Aboriginal lands that were proved in the federal court. And the federal courts or the Indian Claims Commission said that the only reason they did that was because other tribes in Arizona overlapped with Gila River and Salt River's Aboriginal claims area, that they wanted everybody to more or less get a piece of the pie. So that was their reasoning for doing that. But to say that Aboriginal territory It's only from the Indian Claims Commission, the historic judgment.
Tim, do you have any comments on that?
I'd actually like to hear from Stephen or Brady about this distinction between acknowledged Aboriginal land and what's the other one? Because there's a legal basis for that distinction that they're trying to do in the regulations.
Stephen or Brady, are you willing to try to deal with that here, or do you want more time to consider it? I can't.
The distinction, this is Stephen, the distinction
Thank you.
that is that the adjudicated Aboriginal land is the definition of that is from, to a large extent, from Section 3 of this statute. That is the one that Congress gave us for, which is 25 USC 3002. That's the one that Congress put in for those excavations, and it only refers to a final judgment of the Indian Claims Commission or the United States Courts of Claims. The draft regulation has another sentence that talks about how that works with settlements based on our research. The acknowledged Aboriginal land definition is one that Congress did not provide, and is taken from some of the work we did with the culturally unidentifiable remains regulations and practice since then, or our experience since then. So it is a broader definition that is being used for Aboriginal land claims under Section 7 for repatriation from museums or federal agencies. Those are the differences.
So Stephen, this is Frank. So that broader definition you said is based upon practice?
It is based upon the culturally unidentifiable human remains regulations, and then on experience, on questions we've answered and experience since then, since those regulations.
So this change to regulations isn't based on the law. It's based upon.
It's not based on the statute itself, no.
Right. Doesn't that go against the?
This does not, I'm sorry, Frank, I interrupted you. Go ahead.
No, that's okay. When we were drafting the first set of regulations, we were constantly reminded that if it's not in the law, we can't make it into a regulation. But you're telling me that in fact that happened.
It happened, and it does happen. A regulation is an agency promulgates regulations to implement the statute. But so regulations have to be consistent with the statute. But Congress leaves holes in statutes, sometimes intentionally for agencies to fill, and other times they just do. And so one of the functions of regulations is to fill those holes and expand on what Congress did to be able to fully implement the statute. The regulation cannot contradict the statute, but it can act as a fill of the hole. And there is discussion of this there will probably be discussion of this in the preamble to these regulations. There is certainly existing discussion of this. I remember because I wrote part of it. in the final preamble to the culturally unidentifiable regulations.
Yeah, I would just add to what Stephen is saying that this exact point was addressed 10 years ago when this concept was incorporated into the regulations.
Yes.
1011. The idea behind acknowledged Aboriginal land is not new. It's in the current regulations. This is the first time it would be set up as a defined term in the definitions section of the regulation with adjustments or clarifications to the language. But the Secretary's authority to implement the statute has been exercised numerous times, and this actually isn't really a new thing. So I don't think we're looking at towards a new statutory authority. We need to implement this definition as how where it's being placed within the regulation relative to where it currently sits in 1011, and then providing clarity about some of the terms that were maybe unambiguous at the time, including what sort of treaties you look at, or executive orders or statutes as are referenced in the existing regulations right now.
Going back a little bit in history, and I was not working on NAGPRA at the time, but when that part of the regulation was adopted, there was substantial disagreement about it. Is that a fair statement?
We received several comments, concerns. Yes.
Yeah. Okay. So so now we're being asked to, or well, now you're proposing, I should say. We're not. We don't know what we're going to say about it as a committee, but now you're proposing to expand it further.
I don't think it's an expansion of the existing right as much as an expansion of the existing terms, consistent not only with the statute, but with some of the intent that you can see in the preamble back when 1011 came out.
And we answered all of those concerns in the final preamble to the final regulations, which I referenced earlier, right?
So to the extent there was concerns with those, with this concept at that time, it would have been addressed in the response to comments in the preamble when 1011 came out and the CUI rule became law.
And those regulations have been in place now for over 20 years, and there has not been a legal challenge to them, either when they were promulgated or since.
I'll just clarify your math there. It's only been 12 years since the.
Fair enough. 12 years. Thank you.
Over 10.
Over 10, yes.
Over 10. I've been here for over 20 years. It all runs together.
And how I'm sure I could do research and figure out how to get a copy of that preamble and that original publication of that section, but is there a copy?
If you look at the well, Melanie may be bringing something up here.
Yeah, the National NAGPRA website already has all of this.
Yes, the National NAGPRA website.
Okay, the regulations.
Yep, it's all right there.
Both proposed and final versions, as well as their preambles. All regulatory information related to NAGPRA can be found on the National NAGPRA website, as Melanie was probably going to say, and then I cut her off probably.
I was glad for the excuse to pull it up because it was exactly 12 years ago today that these regulations were published.
Oh, look at that.
I thought it was the 15th,
How about
but I wasn't sure.
There you go. So yes, they've been around for exactly 12 years.
As I've mentioned in prior meetings, I would encourage the review committee to consider as part of its recommendations focusing on the practical impacts of the proposed revisions to the extent they exist, whether they are helpful to the repatriation process or harmful. Your all special expertise in that area is very useful. On questions of legal authority or sufficiency, the secretary already pays probably too many attorneys to assist her on many of these matters. That's not really what she's asking the review committee for. at this time. So we appreciate the comments. As Melanie mentioned, if individuals have concerns about any legal aspects of the proposed rule, they are welcome to submit those individually. The committee is welcome to discuss these matters, but in the end, I can't encourage legal recommendations from the committee, as they're ultimately going to come back to the solicitor's office for review, which is already opined on the legal sufficiency of this draft.
Okay, well, good. Let me take you up on that offer, because I have some concerns, which is actually in the next comment down about the definition for acknowledged Aboriginal lands, is that it may not be a new term. It is a new term. In my view, it's a new term that's being applied more broadly. Now, we could debate that as well, but the Congress, and at the time, at least, I think the department felt that it was important that the Indian Claims Commission and the Court of Claims, which had a long history of reviewing land claims, as Barnaby alluded to, were the two sources of information on Aboriginal lands, which is an important concept, as Barnaby also alluded to in his comment. And my concern, one of my concerns, I guess, is the quality of the evidence that is now being expanded to fit under this new term, and who would sort of referee that in a dispute. For example, you don't have the Court of Claims or the Indian Claims Commission to go back to and actually, find a decision that's based upon some kind of a court proceeding, which involved a lot of historical research, to reach a determination about where tribes were located at particular points in time, and where there were multiple tribes, and a lot of those important details, which, when you get down to individual cases, can have a big effect on how disposition is accomplished.
If I might, I could summarize this for you pretty quickly, Frank. The use of treaties, acts of Congress, or other sources beyond the Indian Claims Commission really comes out of the review committee's recommendations on culturally unidentifiable. The final recommendations from this review committee in 2000 identified the need for additional sources beyond the Indian Claims Commission in determining the disposition for culturally unidentifiable. So that's how it really came to be, and all the details of that are, as we mentioned in the preamble to the final rule at 1011. But in general, it was the recommendations of this review committee to use those sources.
Well, I understand that, but they didn't do a review at the time that said, they didn't do a review of the quality of the evidence in those. They said, there are these other potential sources of evidence, or there are these other evidence that might be looked at or that can be looked at. But my question still goes back to, can we believe, or do we want to rely upon? And I'm not just talking about the museums, I'm talking about the tribal and Native Hawaiian organizations as well. Is this evidence reliable for reaching decisions about whether one tribe or another tribe has an acknowledged Aboriginal land claim?
So, yeah, I think I get where you're going with this. And this is a common question that we get in advising museums about applying the culturally unidentifiable rule. It's important to remember that identification of tribes who can claim disposition under the culturally unidentifiable rule is very broad and should include all of those tribes that signed treaties for a specific location. So the list can be quite broad. And in fact, many times the list of tribes that are in a notice under the culturally unidentifiable rule are very long. Once that notice is published, once claims or requests are made for disposition, if there is a competing request, then it would be on the museum or federal agency to evaluate those various requests and to try to identify who is the most appropriate claimant or requester. So, but in the initial stages of identifying who's entitled to these remains, to make requests for the disposition of these remains, there's no requirement for any kind of adjudication or establishment of a hierarchy. Any federally recognized tribe that has signed a treaty, has an act of Congress, or has other recognized Aboriginal ties to a location should be included in a culturally unidentifiable notice.
And I would add to that, Frank, that most of the sources that we are talking about in this definition are documents that either say that there is, say something or don't. So it has been, the question, the regulation, the draft regulation says has been recognized in any of the following sources. Either the treaty at whatever stage it is says something or it doesn't. Either an act of Congress says something or it doesn't. Either in an executive order says something or it doesn't. There is no examination needed for the verification to verify any of those.
Well, Stephen, you come really close to saying if it's written down on paper, it must be true. And
we're giving sources. Those sources are reliable sources.
Well, I would say it's the same source for all of this work, which is an act of Congress. I mean, there is a weight to these documents that I don't think it's just a piece of paper. These are treaties with a government and a tribal government, or acts of Congress. Those aren't just pieces of paper.
Well, I was just kind of sort of just using the allusion to the document as the source of all knowledge, as kind of a rhetorical point there. But what's written down on documents may or may not be true. And I take your point that the kinds of documents, some of the kinds of documents that are listed in the proposed regulation are probably more reliable in terms of geographical location of tribes, territorial claims than others. But the problem I have is that, well, there's two. One is it's not in the law to begin with. And it's not in the law because the people that put the text together chose to go back on to use existing information that were, investigated for 30 or 40 years in terms of the research and the determinations done by the Indian Claims Commission and the Court of Claims, as opposed to some other or additional documents. And my point is that who is going to apply that same sort of rigor to the evaluation of information in these other documents? You say, well, the tribes can bring forward these documents, and that's true. And then the museum or agency could also evaluate them. Maybe the issue here is how much time do we have to actually do the kind of evaluation that should be done to make sure that the proper dispositions occur. Because once the disposition occurs, that's you can't sort of step back or have a redo. So
If Brady,
that's the nature of my concern.
I just want to clarify that we're talking about a term that only applies to those human remains in collections that are culturally unidentifiable currently, for which no cultural affiliation could be determined. That is the scope of this acknowledged Aboriginal land use. And I would point to, Frank, the provisions in the law that say the review committee will determine a process for the disposition of culturally unidentifiable. So that's where this is rooted in the act itself, is in the review committee's responsibility to recommend a process for disposition. That process that was recommended in 2000 by the review committee was based on treaties, acts of Congress, and other documents. So it's just an extension of that provision in the act itself that has played out over the last 30 years of this process. So I want to be clear that this isn't coming out of thin air. It's not even a recent development. This is a long-standing part of the process for disposition of culturally unidentifiable.
Well, and we've had disposition requests in the last two of our meetings as well. But my sense is that if these revisions went through, that process, which requires people coming to the review committee with information and putting all this information together, and the committee making a recommendation to the secretary, that process would end. You wouldn't need to do that anymore. So there wouldn't be that kind of review.
Well, it currently does not need to come to the review committee if there is a treaty or an act of Congress. That's provided for under the culturally unidentifiable rule. So for the last 12 years, you haven't had to come to the review committee if you could identify Aboriginal land.
Well, but it seems like people have continued to do so. Maybe they want that extra level of review and certainty before
Mr. Chair, Frank, the dispositions coming before the review committee are those that fall outside of 1011, for which what is called in this new role a geographical affiliation, but for which acknowledged Aboriginal land can't be ascertained. So the authority on which the review committee has been hearing the dispositions, many of which you've over the past year, is distinct from 1011. I don't think museums and tribes that can work through a repatriation process without having to come to the review committee are coming of their own volition. I think they're proceeding with repatriation because they have the authority to do so under 1011 at present. I'll add only that I had raised my hand earlier, but it was essentially to state what Melly had pointed, just to clarify that adjudicated Aboriginal land is still a concept, and in particular under Section 3, because that's where Congress told us that adjudicated Aboriginal land matters for those determinations. Acknowledged Aboriginal lands is a new name for a term that already exists in the reg and was based on recommendations from the review committee, which Congress asked for to help define the process for disposition of culturally unidentifiable human remains. So again, a lot of this information is available already in the regulatory documents related to the 2010, 2011, 1011 rule, which you can find on the National NAGPRO website. And while the review committee can consider revisiting its recommendations or trying to narrow the scope or limit the repatriation processes allowed under 1011, I don't know if that's necessarily consistent with many of the comments that have been received both back in 2010 and today. So I'd recommend considering that as you're going back and kind of digging through these prior rulemakings that you might have questions about.
Okay, well, thank you. I do appreciate this additional information, and I will think about it from my perspective as well.
Glad to be helpful.
I'm afraid I've hogged the question platform here. Are other members want to comment or have questions for either Brady or Stephen or Melanie, for that matter, on this particular topic? actually can't see John or Honor's screen, so I don't know if you have your hands up, but if either of you do, or Shelby for that matter as well. If anyone does have a comment. Well, Madam DFO, maybe let me suggest something here. Maybe we will return to this topic or take on the next topic at our next meeting. But I know we have some business that you wanted to try to cover before we adjourn here, and I think we are, what, 20 minutes or so from that point. So do you want to raise what the new business or old business additional issues are? And does the review committee agree with that? We should move on maybe for now and return. We'll need to return to go through the rest of our document at our next meeting. Tim, I'm sorry, you got your finger up.
Just one thought. Could we briefly sort of discuss the idea that maybe we should pull together whatever comments we've come up with up until this point and see if we can do a revision of that,
A revision of
what we have discussed thus far.
on the specific?
Not on this particular issue, because I think we're mid discussion, but of all the earlier things that maybe we've resolved.
Okay.
That we could do that offline.
Right. So maybe go back to the the February 11th longer document and insert some text where we've had a discussion, or just a new document that, you know, by section by section says we've done this on this and this on that. And
yeah, but if we could take that back and forth amongst ourselves and then reintroduce it at the next meeting.
Do I have any volunteers or volunteer to put such a list together that we could, so we could begin to say, well, these things we've talked about, we've either made a decision or we're going to come back to it. And then going forward, we could just add to that after we keep going through the different sections. Shelby.
John, I will try and have something drafted to you tomorrow. And whoever's going to be putting this next round of documentation together, we'll get that to them. And by the end of this week. How does that sound, John? Okay, thank you.
Okay, thanks to both of you.
If you're not volunteering to collate, Frank, I'll do it.
I was trying to avoid that in this particular instance, but I'd be happy to do some review, and I think the other members would be as well. So maybe you could start the ball rolling, Tim. And you did a great job of collating the first set of comments, so that'd be great.
And I'll work on everything up to, but not including acknowledged and adjudicated Aboriginal land.
You can say it was a matter of discussion. How about that? So we know where to start next time, maybe. Thank you. Okay, Madam DFO.
So the item I had was a continuation of your discussion on the 7th member.
Okay. And I think we had identified two. We identified two individuals, I think, for consideration, not necessarily to be on the list, but Shelby, I think, mentioned Chip Corwell and Tim Eddie Ayau, which is not his Hawaiian name, but Tim knows how to actually pronounce that, and I don't, but it's that individual anyway. So now we see if there are other individuals.
Yes, Frank, this is Barnaby.
Yes, Barnaby, go ahead.
As far as I know, the honors position is not from a museum, and or it could be anybody, a museum or a tribal representative. Have two considered people from two different museums. I've only spoken with one so far. That person agreed and believed that they could serve on the committee. And then one tribal representative. I don't know if you want their names now or how this is going to work, if they're all going to be compiled, with their background information, and then the committee reviews the candidates more or less for membership. How does that work?
I think, and I can be corrected if I misremember this, but my understanding, Barnaby, is that we need to produce a list from names of individuals we think as individuals would be good in that 7th member position, and we need to have spoken with the individual whose name we're going to put forward, and just get their agreement that if they were nominated by the committee and their name was on the list sent to the Secretary of the Interior, and the Secretary chose them, appointed them, or wanted to appoint them, that they would say yes. So it's sort of a prior commitment, but only one person from that list will in fact be the Secretary's appointee. So it might be that if you have one name with the person you've spoken with who agreed to put that name forward, but maybe then if there's another individual who you think would be good, but you haven't had a chance to talk with them yet, we might sort of revisit this issue at our next meeting and come up with a final list at that point.
Okay, I have one, the one that agreed or said that they were interested and willing to be on the committee. I spoke with her over the phone, and then the tribal representative, I was handed a message during the meeting and it's saying that they want to be on the committee and would, accept any kind of nomination for it. So I have those two.
Okay.
I think that's sufficient, Barnaby, if you would like to share those two names with the committee.
Okay, the first one is Lindsay Bogle-Teeter at Pueblo Grande Museum. And then Angela Garcia-Lewis with the Salt River Pima Maricopa Indian Community. And those are the only two. And yeah, that'll be fine.
Great, thank you very much.
And
Thank
are we pulling together resumes for them, or?
No, we will do that after you submit your list.
Honor, do you have anybody, one other?
I'm sorry, but Frank, Honor can't recommend anyone.
Oh, because she is the 7th member, is that right?
Yes.
Sorry, I didn't realize that. John, then, I can't see your screen, so I don't know if you have your hand up, but John, do you have anybody you want to?
I put some contacts out, and I'm waiting for a positive response. So I'm not gonna.
Okay, no, that's fine. Yes, I understand. I had a similar kind of a situation myself, as a matter of fact. So I would appreciate it if we could maybe put together who we've already spoken with and have said yes, they'd be willing, but leave it open till next meeting on the 21st. We fill out the list, and then we have to agree among ourselves to all the names that we want to send forward. So I do have two individuals who I did speak with, who I think would be good seventh members. I think they're both, they both have experience with NAGPRA. They've both actually been members of the review committee in the past, and they have, long histories of involvement with museums and with repositories and issues related to repatriation and disposition and all of that. First one, some of you may know, some may know one or the other of these or both of them. The first one is Alex Barker. Alex is an archaeologist. He is currently the director of the Arkansas Archaeological Survey. That's a position he's just taken, a very prestigious position within the archaeological world in the United States. He has a great deal of museum experience as well. For the past 14 years before he moved to Arkansas, he was the director of the Museum of Art and Archaeology at the University of Missouri. Prior to that, he was vice president for collections and research at the Milwaukee Public Museum. And he was also a interim executive director and held several other positions at the Dallas Museum. He served as president of the Council for Museum Anthropology and as treasurer for the Society for American Archaeology. So he's well-versed in those organizations, both of which have played important roles in the implementation, in fact, the development of NAGPRA. And as I said, from 2011 to 2015, he served on the review committee. So he's very familiar with the work of the committee and its functions. So I would like to put his name on the list for us to consider if at this point, at least. The second individual, also, as I mentioned, former review committee member, and that's Vin Stepanidis. And some of you may know Alex. I'm not quite sure. I know at least a couple of you are pretty much know Vin. Vin is also an archaeologist. He was the director of the Research Laboratories of Archaeology at the University of North Carolina, Chapel Hill for nearly 30 years before stepping down from that position in 2016. He's a professor at the university now, and during his tenure as a director, which included the period when NAGPRA was being originally implemented through really contemporary times to 2016, he dealt with how NAGPRA would be implemented at that level, at the local level, with collections that the research laboratories of archaeology at North Carolina had under its care at that time. As the director of that organization, he pushed and helped develop good working relationships with the Indian tribes that most of those collections relate to. That's specifically the Eastern Band of Cherokee and the Cont'd tribe. And that work continues at the laboratory with Vin's support and participation, and includes consulting on NAGPRA matters, repatriation of cultural items, and most recently working on museum exhibits and other public interpretation matters with the Cont'd tribe, which is currently based in South Carolina, but obviously aboriginally was occupied parts of what's now North Carolina as well. Then served on the review committee from 2004 to 2009. He currently serves on the Smithsonian Museum of Natural History Repatriation Program Committee, and I think that's where Shelby and he have crossed paths during their mutual tenures there. Then, like Alex, has good experience working with tribes at the local level, overseeing a large repository, a museum with substantial amounts of cultural items. He has a deep experience with NAGPRA because he was actually one of the participants in the working group, which represented tribal representatives, museum representatives, and scientific organizations that actually drafted or did a lot of the drafting of the law in 1990. So he has that kind of deep experience as well. And he has a national perspective as well on repatriation matters. and I think a broad view, as does Alex, on the importance of developing good relationships, the importance of listening to both sides, or as many sides as there are. Sometimes, as we all know, there's more than two for these issues. So I think both or either of them would be a very positive member, which other members of the review committee could work with in a good way. I do have a couple of other people that I haven't heard from yet, and certainly by the meeting on the 21st, I should be able to either suggest them or not, based upon their response to this request. So thank you, fellow committee members. So we've got quite a list. I haven't kept count just now, but maybe Madam DFO could send that out to all of us so we could start thinking about that and about the 7th member role, which of course Honor has filled out and functioned as very well. So we need to find somebody who can step into those shoes as well.
That is a total of 6 names.
Okay. Thank you, Madam DFO. Any other comments from the committee on this particular matter? Is it okay if we hold off actually trying to select who we will put forward at the March 21st meeting? All right, thank you very much for that. I appreciate it. Madam DFO, we've come again to the near end of our meeting here. Are there other? We dealt with the subcommittee for the annual report last time, I think, and then that the volunteers there were myself, Tim, Shelby, and Honor, I believe, on that list. So we've got that. We got that bit of new business taken care of last week. Are there other immediate things that do we need to do anything else today, I guess, is part of my question.
Well, Tim had asked me to provide more background on the OMB information collection process and the difference between what's estimated in that document and what we fund through the grant program. Given the timing, I think that's probably better to wait. I would just make one correction for the record, and that is, in my haste to answer your questions, I misstated the name of the act. I knew it was the PRA, but I said it was the Public Records Act, and in fact, the Paperwork Reduction Act is the legal requirement for that document for information collection under all. It was just not coming to my brain last week. So I did want to be sure I corrected that for the record, that it's the Paperwork Reduction Act under that authority that the information collection is published. So I will plan to provide you with that information at your next meeting.
Okay. Thank you, Madam Chair. I think that's a good idea. And thanks to the review committee members and the NAGPRA program staff and our resident attorneys for the discussion today and for all the work of implementing the statute.
And I'll just clarify again for the record that we don't have any requests for public comment. So while we did not make a call for it, the chat has been open and I do not see any hands raised or any requests. If anybody would like to get on the list for public comment, you may do so by emailing me at nagpra_info ahead of a meeting or during a meeting.
And Madam DFO, I noticed in the chat, there's a lot of links to other documents. Can you make a copy of that and send it around, at least to the review members, so we can go back and refer to it? It also has it looks like quite a bit of text for some of the comments. So it'd be useful to be able to have that.
Certainly.
Thank you. Thank you. Any other last minute comments from committee members? So if not, thank you again, and thanks to those who have agreed to do some compilation in terms of Tim and Shelby and John for a duty of care. I think those are the two that we were going to focus on right away in any case. So thank you very much, everybody. Have a good rest of your week, and see you in what, 6 days? We're going to do this again in 6 days, Madam DFO?
Yes, we will meet again on Monday.
Okay. Thank you, everybody. Meeting is adjourned.
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 Thank you.
Have a good night. Bye-bye.